So for those who don't know me or know me, I am Siam Hussein. I am the founder and CEO of Algorithm. We are dedicated to aid the immigrants in the US, primarily for two sides. One is to achieve financial independence, and another side is to navigate the quickest route to get green card or secure their permanent residency. So these are the two sides we help with. I was an immigrant myself. I was an international student. I went through all the typical international student or immigrant struggle. I was a F1 student, went through OPT extension, H1B green card. 2 years ago, I became a US citizen, so I pretty much know the entire hula hoops of what are the struggles on the pathway. But as a part of the mission, we collaborate with immigration experts and who can bring you like valuable insights and guidance. So today we are excited to partner with Gondim Law for this, hopefully this useful webinar. And I hope that I will not butcher the names of our honorable speakers, but I'll make a quick intro and then I'll pass it to the guests themselves to kind of like introduce themselves. So first, I would like to introduce Julia, who I believe originally is from Brazil. He is a California-based licensed attorney who has a rich background in immigration law. And then we have Caroline, who is licensed in Massachusetts. And she also brings an interesting perspective from her time at Sao Paulo Public Defender's Office and also as an immigrant herself, like a paralegal in California. So I hope I didn't mess up any of the details. Just wanted to welcome you guys and kind of like thank you for giving your valuable time for our attendees today. So without any further ado, I will pass the mic to you. Maybe let's start with Julia. I don't know actually who is going first. I think the first segment is EB-2 NIW for 15-20 minutes. And then we'll discuss about O-1 visa for 15-20 more minutes. And then we'll go with Q&A. So I'll just pass it to whoever is the right person, but welcome again.
Perfect. Thank you, Sam. Thank you for the introduction. So I'm not going to waste any time and I'm going to jump into a little presentation that I prepared so I can present what is the EB-2 National Interest Waiver Visa about. And keep in mind, it is a very, it's a superficial introduction, right? So it's just so you all have an idea of how to, what it is and how you can put that together. But of course, get, research about it or get professional help if you're intending to go through that path. Let's go through here. Okay. So let's start with what is an EB-2 National Interest Waiver. So basically it is an employment-based immigrant visa, a green card through work, right? It is a peculiar kind of green card because in this case, you are self-petitioning. So you don't need an employer in the US, right, to be able to petition. So in order to understand what is the EB-2 National Interest Waiver, it is always good to go back and understand what is an EB-2, like the regular category, right? So in an EB-2, you will need an American employer. You need a company applying for you through a job offer, right? And to do that, the company needs to go through a process that we call labor certification, which is a tool that the government uses to protect the American labor market. So just to guarantee that that hiring is not affecting the American workers. So it's not stealing jobs from American workers, right? So that's the basic premise here. So if you have an EB-2, a regular EB-2, you need an employer who will go through a process that we call labor certification, right? To guarantee that that hiring is not affecting American workers. So in a national interest waiver kind of case, we are asking the government to skip that process. So you're asking the government to skip the labor certification, to get the waiver for the labor certification, because it's in the national interest that you skip that process and you come to the US to work, right? So when you understand that, everything becomes easier to put in perspective, right? So going into the EB-2 national interest waiver, going through the process of self-petitioning, not needing an employer, an American employer, and presenting your case to immigration. So who is eligible, which is the first part of this big kind of case. So you have two ways to show you're eligible. You either can show you have an advanced degree, or you can show you have exceptional ability. Advanced degree is very simple, right? You have to show you have a master's, a doctorate, or a bachelor's plus 5 years of progressive experience after your bachelor's, right? So very simple. Show your degree, your diploma, you prove your experience through letters from your previous employers, and you're good, right? Exceptional ability is a little more subjective to prove, because it's a concept. So the concept for USCIS of exceptional ability is that you have to prove you have a degree of expertise in the field. So for exceptional ability, as I was saying, you need to show that you have a degree of expertise that is substantially above the average in your field. So it's a subject concept, right? So immigration helps you, giving you a list, 6 list criteria to show that you have that degree of expertise. I'm not going to go into the details of that, but that's on the USCIS website, and it's all over the internet. You can research about the criteria, but it's basically, if you don't have at least a bachelor's plus 5 years, then you go through the route of exceptional ability, right? But you have to show through the criteria that you actually have exceptional ability. So that is the first part. You just showed eligibility. Then you go to the second part, which is the actual waiver, right? So for convincing USCIS that you deserve the waiver of the labor certification, you have to follow a precedent decision, which we call Danazar, matter of Danazar there in the screen. And that decision is what USCIS uses to analyze your case. And according to that decision, you have to show 3 things. First, you have to show that the project that you intend to develop in the US has substantial merit and national importance. Second, you have to show that you are well positioned to advance that project, that endeavor, right? And third, you have to show USCIS that on balance, receiving the waiver, it's positive for the US, because you're going to develop something good, something in the national interest, right? So these 3 prongs, it's what we call the 3 prongs of Danazar, are the 3 topics you have to follow. You will structure your petition around those 3 prongs, those 3 topics, right? But let's get into each one of them. So for the first prong, you have to show the substantial merit and national importance of your project. So you need to have a project. We basically only work in 2 kind of setups. And this is a tip from someone that works in the area, right? It's always better to present your project either in a business plan format, if you're proposing to open a startup, a company, or to present a research project, right? If you, let's say you are more of academic background, you have publications, research, you have experience with research, so then go through that route. So it's not impossible to approve a case without a business plan or without a research project, presenting, for example, just a professional plan, a career plan, but it's harder and it's getting harder and harder. So a tip here from someone that works in the field, just present a business plan or present a research project. And what immigration will analyze after, of course, you detail your proposed endeavor in one of those documents is basically the national or global implication of your project and the potential economic impact and job creation. Those are the two. There are others, okay? There is a list of non-exhaustive criteria, but these two are the most important. So, for example, if you're presenting a research project, you may focus on the national implication of that project. Let's say it's a medical research. So show how that your research will further knowledge in that field, right? Or implication in other projects related to the field of your expertise, right? If you're presenting a business plan on the other side, you can focus on the potential economic impact of the project or the job creation of the project, because with a business plan, you have metric to show, to calculate how many jobs you will create, how much in taxes you will pay, right? So it's easier to focus on the economic part of the criteria here when you're presenting a business plan. Of course, always good, as I said, to consult a professional or do your own research to see how you can present that, because it's all about presentation, right? The USCIS can only analyze what you put out there, and they can only analyze as good as you can present it, right? So second prong, after you presented your project and you made a point of how important it is, or the substantial merit and national importance of your project, now you're gonna make a point of how you are well positioned to advance that project. And it's all about linking the project with your own career, right? So the factors that USCIS will consider in that part are related to your education, your skills, your achievements. So everything related to, degrees, certifications, courses, if you ever, if you have media, publications. So everything related to your career, it's good to showcase here. We also use letters of recommendation, which is very important in this kind of case. The letters of recommendations are never it's not a compliment letter, right? That's where a lot of people get it wrong. It's not a letter complimenting you and your work, but it's a letter showing results. What did you do in your career? How did you do it? What are the highlights of your career, right? So again, there is plenty of guidance on the internet on how to build those recommendation letters, and those are actually very, very important in a case like this. We also tend to include an expert opinion letter, also a third party, usually someone from the United States, that will analyze your documents and issue an opinion as an expert in your area, and tell USCIS if your education, your skills, your achievements are make you well positioned to advance the endeavor, the project that you're presenting, right? Another very important point here is financial feasibility. So USCIS usually wants to see if you are able to invest in your project, especially if it's a business plan, for example. For instance, if you are presenting a business plan, USCIS wants to know if you have the money to start your business. So usually your business plan will tell you, oh, you need $50,000 to start your business. So how are you going to get that money? USCIS wants to know if you have a plan. Do you have an investor? Do you have this money to invest? Do you have assets in your country that you can potentially sell and later invest? Because remember, it's all about intention here. So I'm telling USCIS that I want to invest in this business. I may not even have started yet, but I'm showing you that I have all the means to actually execute that plan, right? Another point that is important is progress towards your project. So things like potential clients, if you have a business plan, or did you register the company yet? Are you looking for a physical space to open your business? So things like that show that you're moving towards materializing that project, right? So USCIS also sees that as a positive point. And in the case, for example, of a research project showing that you are in contact with a university that has interest in developing your project, right? So interest or support from relevant entities is relates directly to research projects where you can show that there are entities that want to develop your research project, showing communication, emails, letters, all that can show, that there are American players wanting to invest in your idea, in your project, right? So it's all about showing USCIS how you are ready to materialize your plan. So you don't need to have anything going on yet. Of course, it is positive if you have something in motion, right? If, for example, in the case of a business, if the business is already open and operating, great, because it's more than a plan, right? It's already in motion, but it's not a requirement. What it's the main thing here is to show USCIS that you are ready and capable of putting this plan in action. So jumping to the third prong and the last one, we have to show here that it is in the national interest that we skip the label certification process, which I explained in the beginning. So just to show USCIS that there is no harm in skipping the label certification process. Actually, there will only be benefits to the USCIS, right? To the US, I mean. So one of the things is showing the impracticability of the label certification process, because if, for example, I'm opening a company, it is impractical to make a label certification for myself, because I'm creating a company and I'm employing myself. There is no way I can go through a label certification and employ myself, especially if the company is not even open yet, right? So there is no employer yet that can go through the label certification for me, right? So this is very easy to show when you have a business plan, right? When you have a research project, for example, you can show the urgency of your project within the field. Like you're furthering research in, let's say, in cybersecurity, in cancer, in anything that you can show somehow you can link the urgency of your research and the applicability of that research in the field, right? The same would be to show the benefits for those contributions, either on a business standpoint or research. The same things that we discussed in the first prong about the national importance, you can discuss here again to show the benefits of your project, the contributions that you'll do through your project to the national economy, to the field. In the research project, it's hard to show, sometimes it's hard to show potential economic impact and job creation, but that's very easy when you have a business plan. So again, you will bring to the table the jobs you will create, show that, hey, I'm not stealing anyone's job. I'm creating my own job, right? I'm not applying for a job in a American company. I'm actually creating my own job. And by doing that, I'm going to be able to employ American workers too, because I'm, employing other people. And that's a very compelling argument, actually, right? So these are basically the third prong is basically legal argument, right? Everything you need to produce in terms of evidence goes in the first and the second prong. And we're just tying everything together in this third prong is a lot of legal arguments. You don't need to produce any specific document or evidence for the third prong alone. Okay. So this concludes our overview of the EB-2 national interest waiver. I know it's a lot of information. I try to kind of go over everything you would need to put a case together, but we can go into the specifics during the Q&A. So that's it, guys. I will pass my turn to Caroline now.
Yes, thank you. I was not able to unmute myself.
I was seeing you, and I'm like, do you need help, Carol?
No, we're all good now. Thank you so much for inviting us. It's a pleasure to speak to all of you that have gone through what we have gone through. Julia and I both came as students, and we went through different processes to get our green cards. So we know what it's like to come to this country and still want to be a professional here, and the different ways that you can go through that. So let me just share my screen with you. So we're now going to talk about the O-1 visa, more specifically the O-1A visa. It's not as common as the EB-2 NIW or the regular EB-2, but it's also a good option for status here in the United States, work authorization, which is also important. So it's an option that you could have, and it's one of the better options that you could go for here in the United States. So basically, the O-1 visa is a non-immigrant visa for professionals with extraordinary abilities in their fields. It's divided between O-1A and O-1B. The O-1A category is applicable to professionals in the fields of science, education, business, or athletics. Meanwhile, the O-1B is more commonly used for professionals with extraordinary abilities in media. So the O-1A category is more commonly used because it's more broad, especially in the field of business. If by seeing this list of science, education, business, or athletics, you do not think that you would immediately fit into one of these 4 categories, it's okay. It's more likely than not that we could actually fit your occupation into one of these fields. Even if it's mainly business, say you're going to be a consultant in your field, you're going to be giving advice on a specific area that you work with, and your role could actually be fit into science, education, or business. Obviously, athletics it's a different field that you actually have to be an athlete or a coach or someone in that field. But the other 3 are more commonly used for professionals in basically any field. So if you're an engineer, we can use you in science or business. It really depends on what you want to do here in the US, what your expertise is outside of the US as well. So if you don't see your actual profession listed, it's okay. It's more likely that we can actually fit your occupation into one of those 4 categories. So the employment in the United States through the O-1 visa is specific to the field of the beneficiary's extraordinary abilities. So let's say you're a top CEO in your company, you're actually going to have to come to the US to work in that same field that you already work with. So we cannot use the O-1 visa to start a completely new career. If you already have your expertise, you're an extraordinary professional in your specific field, then you would be coming to the US to continue working in that specific field that you have extraordinary abilities. So the O visa can be up to 3 years, the first time that you get the visa. It really depends on the type of event that you're going to be doing in the US. So if you're going to be here competing, then the competition has a specific date for you to come. If you're going to be working on a specific research project here in the US, then that project might have a limited amount of time, up to 3 years. If you're going to be doing business here, if you're going to be a consultant or something like that, then we can use it for up to 3 years. It can be a specific project. We have to show what you're going to be doing in the US. So on those years that you're going to be here, you're going to actually be working with specific events in your field of extraordinary abilities. The O-1 visa can be renewed for 1 year, and there are no limits to that renewal. So if you want to stay here in the US for basically your entire career, you can do that with the O visa. You just have to keep renewing with 1 year increments. And as long as you're keeping working on the field of extraordinary abilities, then you're good to renew your visa and stay here with no limits. Most visas, especially the H-1B, they do have a time limit with some exceptions, but the O visa gives you that freedom. If you don't get a green card in the meanwhile, in the first 3 years or after a few years, it's an option that you have because you can basically renew it for as long as you need to. Another advantage of the O-1A visa is that it's actually a dual intent visa. So it is a non-immigrant visa. It's not going to give you a green card at the end of it, but it's not gonna interfere with your immigrant petition, be it that through work and employment-based petition or a family petition. So you're not gonna have a problem, for example, when you come into the US with your O-1 visa and you already have an approved EB-2 or EB-3 application, because it's okay, you're showing intent to immigrate to the US, you want to be here permanently. A non-immigrant visa is not for people that want to live here permanently. But with a dual intent visa, you have more freedom, because even though the O visa is not to stay here forever, that's a green card, you wouldn't have a problem with your immigrant petition. So it's not going to interfere. They can both be filed at the same time. One is not going to interfere with the other. So that's a freedom that you have with the O-1A visa. The O-1 visa does require a sponsor. So the sponsor is the one that is going to file the petition for you to work in the US. And it can be done through 3 different ways. First, you can have a US company file that petition for you. So if you work with a company here in the US and they want to sponsor you, you were not selected for the H-1B lottery, and you're running out of time with the OPT or something like that, then if you do have a company that is willing to sponsor a visa for you, the O-1 can be a good option, because that petitioner is going to file a visa for you. So that's one option. You can also file through a foreign company outside of the US that you either already work with, or that you had a previous experience, or a company that is willing to hire you now, even though you're here in the US, but they want you to represent them here in the US, or they want you to come to the US and work with another company to be consulting on a project, or you want to send they want to send the employee to learn a specific methodology here in the US to bring that back to your own country. So that's possible. You can have a foreign company file the petition, but in that case, since the company is not in the US, they would need an agent here in the US to file the petition. This is mainly for legal reasons, as in the company needs to have someone in the US that could represent them before the law. So if they are not here, they don't have any presence here at all, they would need to work with an agent. So the company would have a contract with any person or company, can be an agent, and then other than the beneficiary, of course, but that person is going to represent the company here in the US. So if anything happens during the process while you're here with the O visa, then the agent is going to represent the company here in the US. So that's another possibility. Also, a very commonly used way to get a sponsor is to use your own company. We recommend that you work with another partner. It could be owned 100% by the beneficiary, but that's more complicated to work with USCIS, because the goal is to have another person in the company that has certain powers over the beneficiary as an employee. It does not affect the person as a partner in the company, but then as an employee, you have to be subject to being basically fired at any moment. That's what qualifies you as an employee for USCIS standards. So if you have another partner that has managing capacities, and one of the specific powers that that other partner has is the ability to hire and fire employees, then we can use that. It's very common. And that person is going to be basically responsible for your work here in the US. They're going to tell you what to do. The manager can be more administrative, and you can be doing the actual activity of the company. For example, if you're in business, then you're actually going to be the one providing the services or consulting on projects or doing audits, or if it's in science, you're actually going to be doing the research or something like that. So the manager does not have a big role in the company. I mean, they can if they want to, but what we need from this partner is that they have specific powers to hire and fire employees, and then you would be okay sponsor-wise. So you have a couple options. Sometimes it's easier to just go through your current employer, but then if you can't find an employer and you cannot get a sponsor outside of the country, then you have the option to open your own company and do the visa for yourself. It's not a self-petition because it has to be done through the company, but it's a possibility to do it with your own company if you don't have another sponsor. This can also be a good option if you want to provide services for multiple companies, or you don't want to be tied to a specific company, because remember, this is a sponsored petition. You need to be working while you're with the O-1 visa. You need to be working with your specific sponsor. If you want to change sponsors, that's fine, but then the new sponsor has to file a petition for you. So you're actually tied to whoever is the sponsor. So if you're okay with working with another company, that's great. If you don't have a company that can sponsor for you, you also have the option to do it through your own company. So now that we have a sponsor, we can actually start working on the eligibility criteria to be qualified as a professional of extraordinary abilities. So the law basically gives us 8 criteria that we can use to qualify a professional. And of those 8, we need to demonstrate at least 3 to qualify as a professional of extraordinary abilities. There's no difference between the 8 criteria. None of them are more important than the others, but as long as you have 3, you can show that you actually have 3. You have good documentation to prove that you have at least 3 of the listed criteria, then you're okay. You don't need to have all 8 to be extraordinary. As long as you have 3, 4, 5, 6, obviously the more the better. But if you have 3, then you are qualified as a professional of extraordinary abilities, and you qualify for the O-1A visa. So receipts of nationally or internationally recognized prizes or awards for excellence in the field of endeavor. Basically, this award has to be considered major in your field, and it's nationally or internationally recognized. Keep in mind that all of these criteria don't have to actually be in the US. It can be in your home country. It does not have to be so recent. It can be throughout your entire career. It can be 10 years ago. It can be 2 years ago. It can be yesterday. So as long as you have the criteria before the company applies for your petition, then you're good to go. We have to have it before we apply, but it does not matter how long ago it was. So if you have an award that is major in your field, then we can use it to fulfill this criterion. Most clients that come to us with the awards or recognitions, they tend to want to use company awards, even if it's major companies, multinational companies. Sometimes it's hard to use just whatever you get in your own work, because it's more tied to what you actually have to do in your everyday job. So it's better to have something more neutral. Say it's done through the government or done through a competition that your employer or your school is not actually related to. Obviously, if it's a major university, for example, that is very influential in your field, then that would be interesting, because it's an important university, it's an important institution, and what they say influences the field. So it really depends, but it's better to have an award that is more neutral than just something that you got just through your work or your studies. The next criterion is membership in associations that require outstanding achievements of their members. So this is harder to achieve because what USCS is looking for is associations that invite you to become a part of that association. And it's not generally available to just any person that wants to join that association. So it's one of the hardest criterion to get for the O-1 visa. But if you do have that in your field, a specific membership that only a few people get selected to join, then we can definitely use that for the O-1A visa. The next one is published material in professional or major media about the beneficiary and his work in the field. So basically, these publications have to be about you and your work in the specific field that you want to use for the extraordinary abilities. And it's published in a major media, website, magazines, or journals or something like that. And it's about you and your work in the field. It can also be published in a specific media to the field, even if it's not very famous, if it's not nationally known, but it's specific, then we can use that too. Another thing that is also important, it can be in your own country or it can be in the US. But what differentiates where you're going to have the publication is where you have experience. Because if you have publications in the US and you never worked here, then it does not look good to USCIS because they can see that was fabricated and that makes no sense because you never worked here and you have publications here. So it's good to connect that with where you actually have worked before. So we do not have set guidelines to what you actually need in that publication, but as long as it's talking about you, mentioning your name, if it's a specific project that you worked with your company and it somehow came to be published and it was important in your field, then we can use anything that is related to that project. The next criterion is participation as a judge of the work of others. We're talking here about other professionals in the same field. So if you work with audits for other people's projects that they have done, they're in the same field as you, you're not hired to actually do the job, you're just hired to evaluate and do an audit of that project just to see if it was done correctly, if they meet the specific field standards, then that can be used to this criterion. Also, if it's in the academic setting, if you're judging other people's work, their papers, their publications, then this can also be used as for the criterion of judging the work of others. If you're analyzing proposals for projects that you're not actually going to be involved in, you just giving your opinion about that proposal, then we use this. So even if you don't think of anything right away in that field, it's more likely than not that you have somehow judged the work of another professional in your field. It's very common for us to actually be evaluating other people's work. So whatever you can think of to be used in that criterion, then we can potentially use that to qualify you as a professional of extraordinary abilities. Then we have original scientific, scholarly, or business-related contributions of major significance in the field. This relates to a project, a method, a product, a strategy, or a study that you have done and that somehow influences the field. If it's in your own company where you work and that's a major company and what you implement there is actually going to influence how the market works, then we can use this for this criterion. It does not have to be a patent. Obviously, that's the easiest thing to think of, a patent or a registered trademark. But if you have something that somehow influenced your specific field, even if it's a method that you applied, today it's difficult to create something entirely new. We know that USS is not looking for a person that created the wheel here, but we can use whatever you can to demonstrate that the project has somehow influenced the field. Like there's a product that already exists, but then you thought of a new way to use that product and it's actually going to impact the field because it's going to either make the automation process faster for that specific field. So things like that actually have big impacts in the field, we can use it to show that you have an original contribution, because whatever little change you make to what already exists, then it can be considered as something different, something original.
Hey, Caroline, sorry for jumping in. Just wanted to remind you that we have 9 minutes left. So if we wanted some Q&A, just reminding.
Okay, let me just quickly finish up then. We do have authorship of scholarly articles in the field, which is more commonly used. Most people have written articles or papers that are published. We can use this. Also, if you do have a critical role within the company that you work, and it's a major company, it's renowned, even if it's not executive level, it's just a very important position in the company, it's also applicable to the O-1A visa. And obviously high salary, if you can show that your salary was above average because you have such expertise, then that can be used as a criterion for the O-1 visa. And just as a reminder, if you don't have at least 3 criterion as of now, it's always something that you can work on before you apply for the visa. You can publish articles, you can find a project that you can actually be a judge of, and you have ways to work on the O-1 visa before you apply. So it's not that hard, it's not a monster to work with, but it's possible. And it's a good option for those of us that want to stay here in the US. So thank you.
Awesome. Well, thanks a lot, Caroline and Julie. I'll probably just dive into the questions because there has been so many questions. I have been just trying to keep track, but thank you so much. This has been so valuable, and I'm sure that they will reach out to you guys with tons more questions later. But let me just try to cover as much as possible within the time. So I think the first questions, I'll go serially. Primarily, let's go with Julia because I think the questions came first. So one person asked the question is that, so this is for EB-2 NIW. Is high salary really important? How high is high salary? Is it 150K to 200K? That's one question. And also the same question asked that expertise in food manufacturing industry, can that be considered as national interest? So I guess the same person asked this question. Oh, sorry. Just give me a second because I do sometimes mute it because otherwise I think you should be good now.
Okay, now yeah, I had the message that you were not allowing me to unmute myself, but yeah. So regarding the high salary, it is how important it is will depend. If you're doing through advanced degree, then the high salary will serve to will be included in the second prong to show you are well positioned to advance the proposed endeavor. Remember that? So in that part, when you show your education, skills, achievements, you can put there the high salary to show that like I have a really good career. I achieved a high level of expertise in my career, and that's why I have this high salary. So that will help to make your case on whether you are well positioned to advance the proposed endeavor. If you're applying through exceptional ability, that is actually one of the criteria on the exceptional ability. So that it becomes even more important because it's on the first part of the analysis, right? When you show you are eligible for the EB-2 category. So the high salary, it becomes more important in that case, but it's not a requirement. It's not that you have to have a high salary to prove either that you have exceptional ability or that you are well positioned to advance the proposed endeavor, but it is always a positive point there. And regarding what is high salary, then you would have to gather data of what is the average of your field, of your profession, right? So you determine the average for your position, and then from that average you show how here my salary is here, therefore I have a high salary. So you can always make a case depending on what the average is.
And thank you. And then the second question, I think, was the food manufacturing industry. Can that be considered as national interest, like expertise in food manufacturing?
So the analysis is not exactly like, oh, expertise in this field or that field can be considered of national interest. It's all about the project that you are proposing within that field, in that case of food manufacturing, right? So of course you can have a project of national interest in the field of food manufacturing, right? Could be a research project and could be a business plan. You could be starting a startup. It doesn't need to be anything new or anything fantastic related to food manufacturing. It could be for a business plan. It could be a startup that you're gonna franchise, and then by franchising you can show that the economic impact of that project within the food industry and within the food manufacturing industry, because of the amount of jobs you're going to create, has national importance. So it's a little more complex than only saying it's, this field, can I show national importance in this field, on that field? No, it's about the project. And even in the project, regardless of the field, for example, I can show national importance if I show that my project will create a high amount of job positions, for example, right? So yeah, it's very flexible on how you can portray your project to be able to show national importance.
Awesome, thank you. By the way, just so for the sake of time, I wanted to ask Julia and Caroline, how long can we stretch? Can we stretch it 10 more minutes? Just wanted to be mindful because you guys are definitely busy.
Yeah, I'm just gonna, I can ask. I have a call, but I can ask for the comprehension of the person to delay
Okay.
a little bit.
Awesome. Okay, sweet. Thank you so much. So,
No problem.
yeah, we will extend it maximum 10 minutes sharp. So, okay, next question. I'll go through rapid fire. Sorry for going so fast. So, another person, I have a 1.5 years master's in chemistry from Bangladesh. I am confused whether this degree will be considered as advanced degree or not.
So an advanced degree is a master's is an advanced degree. So having a master's already, you have an advanced degree. Having a PhD, you have an advanced degree. The equivalent of a master's for USCIS is a bachelor's plus 5 years of experience after the bachelor's. So it's either the doctorate, a master's, or a bachelor's plus 5 years of experience. So if you're presenting only a master's, you don't need to present any kind of experience to show eligibility, right? But remember, when you go to the second prong of Denazar, in the second part of the analysis, the experience you have in the field is important, right? It's not a requirement to have many years of experience, but it's definitely positive to show that you have years of experience. Again, you can qualify with a master's only and show in the second prong that you have a year of experience, no problem. But the officer will take into consideration the years of experience you have in that field.
Awesome. Thank you. And then, all right. So I have seen that EB-2 NIW is generally approved for people who have PhD and certain number of publications. I have a master's degree and just a few years of experience, but without any publication or certification. Does my case qualify to make a good case for NIW?
So for research, yeah, it is. They do look in the number of publications. They do look in the number of citations you have. They usually prefer to approve petitions of people that have higher numbers of publications and citations, but it's not impossible to approve a case with a smaller number of publications, citations, and all that. It will depend on the quality of the work. It will depend on the quality of your professional experience, because you could show that, okay, you don't have many publications, but you have a good track of experience working in universities or in prestigious entities, right? So you kind of compensate and you explain like, yeah, I'm not publishing work, but I was getting deeper in the field by doing these other kind of work. So it's not a requirement. We know that the officers have a preference, or they kind of they think it's very positive to show, publication, citations, all that, but it's not a requirement. Definitely, we have people approved without that.
Awesome. Thank you. Another question for, let me go with EB-2s first. I just concentrated all similar questions. So for EB-2, since an endeavor of proposed business plan or model is required to showcase, does that imply any restrictions to seek jobs in the US market for the EB-2 NIW visa holder? Also, is it required to be in the US to apply for EB-2 NIW?
Can you repeat the question?
Yeah, so the question is, since a proposal of business plan is required to showcase, does that apply any restriction to seek jobs in the US market while someone is applied for the EB-2 NIW?
Okay, so let's see if I understand. Once you present that you want to open a business and start a company, would you be precluded from looking for a job? Not necessarily. You are proposing to open a business. So, of course, once you have the green card issued to you, approved, you have to open that business. It doesn't mean that business you need to be exclusively working for that business you opened. You can have parallel, jobs or any other kind of project, but you have to try to advance the proposed project, right? because then that shows that you were not lying to the government, right? You wanted to open the company, you went there and did it. You open your company and you try to develop. You have no obligation of success. Actually, the company could fail a year or two later. No problem with that. The thing is, you have to try to develop the company. What you do on the side, no problem. As long as it's not conflicted, it's not, contrary to your to the project. So if you have a job that doesn't allow you to run a company, then of course you cannot have that job, because how are you going to run your own company too, right? But yeah, during the process, sometimes you're here in the US applying here, and then you get your work authorization, and during the process you were working for another company, no problem at all. After you get your green card, yeah, you have to try to develop your own company, but no problem if for another few months you also have another project, another job. It's not excluded of all other possibilities.
Awesome. And I think just one or two more questions and EB2, and then we'll go to O1. So is it also required to be US to apply for the EB2 NIW, or it could be outside?
No,
also?
You could be outside the country, no problem. You will go through a consular processing, no problem at all. And you just you would have your interview at the consulate, and then you enter already with your green card approved.
Okay, great. Awesome. So I think this is good. I have someone asked a very interesting question, and this would be great to actually ask you guys. This question is that, thank you so much for this very helpful session. Are you currently offering any free consultations? Given our individual circumstances, a brief consultation would be helpful. So I think any kind of thing you guys can, if you can also, I can also share your link or anything.
Yeah, I think we can work something. I think we can work something out. We can actually, I was thinking here, we can do group consultations, and then I can get people that are interested in the EB-2 national interest waiver and do groups of 6, 8 people at a time. So then we have time to discuss and go over questions and specific scenarios. I think we can work that out. We can talk after Sam, and then you can share with them, but we can definitely work free consultations.
Awesome. Really, really good. Definitely I will. And again, thank you. I don't know if you guys are seeing the chats. Thank you so much. Appreciate you just saying, people. I will still keep going with the questions. And I think, Julia, you probably wanted to leave, so I didn't want to hold you. I don't know if Maria, Caroline, can I ask you also some questions for O1?
Yes, of course.
Okay, so again, thanks a lot, Julia, for answering all these questions. Actually, before you go, I have another question from EB2.
Yeah, of course.
Yeah. So for someone who has previously been on J1 visa with 2-year home residency requirement, can they even initiate the process of EB2 NIW and fulfill the home residency requirement meanwhile, especially when the J1 waiver is not an option? Or they need to complete the 2-year residency requirement first?
That we can start working on the petition. The thing is that they're not going to be able to either apply for adjustment of status or start the consular processing part of the process while they either get a waiver or fulfill the requirement, right? So we can definitely start on the petition side. But if he's not eligible for a waiver, then yeah, sooner than later, it's good to start fulfilling the requirement, and then we can go through the consular process or the adjustment of status process.
Last question on this. So does opening an established business under applicant's ownership help the criteria? I'm not sure if I understand the English, but should this business employ other people? And if yes, what is the criteria?
So opening the business and having the business operating, the business that the business related to your project is definitely helpful. So you're showing that not only I have the plans, but I'm already materializing that plan. I'm already executing that plan, right? You only have to be careful about one thing. Depending on your status right now, you might not be able to work, right? You might not be able to have a work authorization to actually operate your business. So you have to be careful on what is your status now and how you're operating the business. But it could definitely help if you're able to work, if you're authorized to work, and you start operating the business related to the project on the EB-2 national interest waiver. That could be a very positive point to the application. No, you don't have to be employing anyone. It could be a plan. So I have a 5-year plan on the business plan showing that I'm going to employ up to 20 people by the 5th year. But right now I'm just started operating and I have 1 employee, no problem. Or I have 0 employees yet, no problem. It's not a requirement. You're starting the plan. But it is positive to have. We actually advise people, register the company, start looking for a physical premises, maybe get, quotes, like all that shows that you are setting in motion your plan. That's positive.
Awesome. Thank you so much, Julia. I will move to O1 related questions. So, Julia, if you have to leave, thanks a lot again so much for your time.
Thank you. Thank you, guys. And as I said, Siam, we're going to talk to you after, and then we can set up the free consultation so we can help, clarifying the other questions that might come up here.
Perfect. You guys are so kind. Thank you so much.
Thank you all. Bye-bye.
Okay. All right. I will go with O1 questions.
All
Oh,
right.
my notebook is full here. I'm just looking at my laptop and okay, we will have to still keep it on time. I extended it a little bit more, but let me just see. Okay, I think many of the questions were being asked in the beginning, so I think many of those questions were answered. So I guess first question, can O1 be applied from outside the US? Same question.
Yes. The visa can be done entirely here in the US. Regardless of where the person is, it's going to be analyzed by USCIS here in the United States. If the person is here, they can apply for a change of status at the same time. But if they're outside of the US, the petition is going to be analyzed here. And once it's approved, they can apply for the visa at the consulate.
Gotcha. Awesome. Thank you. And then another question is that I heard judging others is one of the criteria. Does judging business IT competitions count, or does it have to be only adults? I mean, judging high school business IT competitions.
Oh, so the criteria is judging the work of other professionals in the field. So high school are not professionals, so that would not qualify. But if it's a regular competition, then yes. But anything that you're not judging the work of another professional in your field, then that would not qualify for that specific criterion.
Gotcha. Awesome. Thank you. Can I hire personnel not from sponsor company? So can I hire a personal attorney and ask my employer to support my case by being the sponsor?
Yes, if you want to, if I understood that correctly, if you want to pay the process yourself, yes, the O1 does not have that limitation that EB-3s and H-1Bs have. So if you want to pay for the process yourself and just request your company to sign the documents, yes, we can do that. Obviously, the company is going to have to be involved in the process because the company is the one petitioning the case. So they have to sign forms. They actually have to sign a G28, which is a power of attorney for the office. So they actually have to be on board with this as well. So you cannot just do the process by yourself. We need to speak with the sponsor and get documents from the sponsor as well.
Awesome. I think we have almost okay, I will pass the whoever has EB2 NIW questions, if you can just I'll just put in the chat. You can feel free to ask the questions in the email. But let's go with the O1 ones. During, I don't know if it is O1 related or what related. So during filing I-485, the job I'm doing right now, does that need to be exactly the same as job SOC code mentioned in the I-140? I think it is too specific.
Yeah, that's
Yeah.
actually related to an EB, an employment-based visa, either EB-2 or EB-3. But
Okay.
yes, the I-485 is the application for the green card via adjustment of status. If you want to get a green card for a petition that you have that is approved, you need to get that green card for the same purpose that the petition was approved for. So you cannot just simply say that you're going to be doing something totally different now that the petition is approved. You need to be in track with what the sponsor already applied for you.
Gotcha. Awesome. Last question, I think. So last two questions, and then we'll wrap it up. Can O1 dependent also work? Like legally?
Unfortunately, the O3s, those are the dependents, they cannot work. They don't have work authorization. They can study in the US full time, but they would not have work authorization.
Gotcha. Okay. And last question, I don't know if it was with O1, but the question is, can I use one scholarly article that I wrote so far? Does adjunct professor in cybersecurity consider as a critical role?
So for each criteria of the O1A, obviously the more you have, the better. But if you only have one document, one situation that qualifies for that criterion, we can use that. It's going to depend on the specific document. Say it's one article, but it's in a globally known magazine. So that has a lot of impact. It carries a lot of weight. So it really depends on the specific document. So say you had a critical role in a major company, and it was only that one employment that you previously had. It does not matter that it's only one. As long as it's strong enough that we can actually extract the criterion from that document, then we can use it. The amount of documents that you have would not really make a difference. Obviously, the more the better. But if it's strong enough, if it's good enough that we can show the officer that from that one publication that you have, you can actually be considered as a professional of extraordinary abilities, then yes, we can use it. For the critical role, we really need to see what the person is actually doing, because if the company or the university thinks that they're actually essential to them, this is going to be written in a letter from the institution. If they say it's critical and the university is renowned, then we could potentially use it. But it's really going to depend on the case-specific facts.
Awesome. I think that is the end of basically the questions today. I know that there might be some more, but this will never end. But thanks a lot, Caroline, for staying longer, and thanks a lot also to all participants to stay a little bit longer. If you have any other questions, and if you need more like individual consultations as they suggested, feel free to just email in immigration@algorithm.com. And then if you have any other future webinar request, you can also fill up this form. But again, Caroline, thanks a lot for taking your time and doing this for us.
Yes, of course. It was our pleasure.
Yeah, thank you so much. And thanks a lot, guys. We'll stay in touch.